as you see there, become a member of the Broadcasting Alliance, the ATBA. And here are some of our sponsors that are our gold, silver, platinum sponsors. And also, if you can go over to our page at broadcastingalliance.org, we would love for you to be a sponsor or even to become a member. For an individual or nonprofit organization, it's just $100 for a year. And then we have many folks here that are major contributions that help us in the fight to be sure that LPTV continues to be relevant in our country. So with that, it looks like the number is starting to steady out. A few more popping in right now. And I'm going to go ahead and stop our share. And our guest for today, I've got on board Ari Meltzer with the Wiley Law Firm, who has been helping us out here at the ATBA, being sure that we are compliant and that we help the FCC, the LPTV industry be compliant with the FCC also. And I've got Josh Wise on board here. We're just going to bring him into the session because, I mean, he has LPTV stations. Maybe he'll check Ari here and be sure that he's doing things right, correct? So he's also, toward the end of our discussion today, answer your questions about last week's discussion. And some of you have been asking about whether we are going to put that online. Yes, we will. There will be an edited version of that online very, very soon. But Lee's been very busy. I just flew in from Las Vegas, getting plans set for our reception on April 25th. And things are looking very good. Also, I was out with Louis Libman. He spoke at the International Wireless Communications Expo, talking about ATSC3 and how us as LPTV station owners can help in the public safety sector and for events and such as that. So let's move on to Ari. Ari, just tell us a brief 30-second rundown of who you are and what you do.
Who I am. I am Ari Meltzer. I am a partner at Wiley Ryan LLP in Washington, D.C. We are a leading firm in the communications space. So I do represent broadcasters, related communications companies, investors, kind of anybody within the communications sphere on issues relating to FCC rulemakings, compliance, keeping folks out of trouble, kind of just trying to do everything we can to represent the broadcast industry.
All right. And speaking of trouble, many of us, I don't have an LPTV station, I just say us, but in the LPTV world have received interesting letters called LOIs. In recent days, we've discussed EAS and the emergency alert system. And so with these LOIs out there, what do we need to do? What's the FCC trying to do here in regards to EAS and LPTV?
Sure. So this dates back to, well, really to the August test of the EAS, the nationwide test. And in addition to running the test alerts, broadcasters who are part of the EAS system were required to file the ETRS Form 1, which says, here I am, here's my stations before the test occurred. Then within 24 hours after the test to file the ETRS Form 2 reporting, making initial reportings on how the test went. And then a little while later, ETRS Form 3 providing more detailed information on how the test went. The FCC released a report back in December about the test and the results of that test. And one of the things that was highlighted in that report was what they described as a low response rate among LPTV stations, that it was lower than full power stations and that it pulled down the response rate for the entire broadcast industry. And that got some attention in the press. I think it drew some attention within the FCC. And in the past, this reporting has been essentially informative for the FCC. There haven't been any enforcement efforts based on it. There hasn't been any threats to the industry based on it. But this time, the FCC has followed up with some letters of inquiry from the Enforcement Bureau that have gone out to a number of low-power TV licensees, asking about, it was really targeted at stations that didn't file those ETRS forms, the Form 1, the Form 2, and the Form 3, asking questions about whether the stations were operating in August, whether the stations filed those ETRS forms, and if they didn't file the forms, asking why they didn't file the forms. I think there's a lot of confusion, and the FCC has really helped feed this confusion in a way among the low power industry about what's required for EAS. So translator stations under the rules are not part of the EAS. They're not EAS participants. Low power stations are EAS participants. However, if they're essentially acting as translators, whether for another broadcast station or whether they're centralized programming, there's an exemption under the rules that applies to that. And actually, if you go back to that December report, there's a little footnote where the FCC describes that and says, our methodology is probably flawed because we don't account for a lot of these stations that are operating as satellite stations and repeater stations. So I think there's a lot of just confusion at the FCC and in the industry about how the rules are supposed to operate, and then what it meant for that reporting, and whether there was truly an underreporting, whether there was an underreporting plus there was a situation where folks weren't really required to report, or whether the FCC was just wrong in its methodology.
Okay, so if I'm a station, mom and pop out in middle of nowhere, Texas, and I get one, and I didn't do anything with EAS, and I think I don't need to be participating in EAS, but I got one of these letters, what should I do?
So the first thing is, if you have a lawyer, you should certainly reach out to your lawyer, because this is an enforcement matter. These letters are coming out of the Enforcement Bureau. So there is the possibility for the FCC to assess forfeitures just for not responding, even if you didn't do anything wrong. Just not responding itself is a violation of the FCC's rules, and then potentially for a violation of the rules as well. So it's important to respond, and it's important to take it very seriously and make sure that your response is providing not only the facts, but trying to frame them in a way to make sure that it's describing compliance with the rules. So first thing is, if you've got FCC counsel, you really should reach out to them and have them help. If you don't have FCC counsel, like I said, this is an enforcement matter. This is probably the time to get FCC counsel involved. And the third thing is to make sure you respond. I mean, at the core, give the FCC the information it needs. We don't know where this is going. We know that this was not a targeted investigation. These letters were sent far and wide. So it may be that the outcome of this truly is information gathering, but it also could result in fines and forfeitures and other enforcement action by the FCC. So I think the industry needs to take it seriously.
Well, you've got a good point there in regards to, and this is not a plug to hire RA for all of your legal services, but it's if you get any sort of letter from the Enforcement Bureau, unless you're really good at the legal side of LPTV, I personally think you should have retained counsel of some sort, or at least consult counsel. But the other thing that I've found that is important in this industry is be sure and find an attorney or a group of attorneys, whatever that is, that knows the LPTV industry. There are many broadcast attorneys out there, and I've seen several LPTV friends that basically have gotten in trouble because they used somebody as an attorney that didn't know the LPTV world. So I don't know how you feel about that issue, and this is not a plug to hire Ari, although we love having you on board, and I'm sure you'll take on more clients if they call you. But I assume in the legal world that there are attorneys that are more specialized in, say, LPTV than full power or radio. Would you find that is the case?
Yeah, I think that's a good point, Lee. And just making sure somebody understands the nuances of these rules, because they are the application to LPTV is so unique, and there is nuance in terms of, you know, are you a translator station? Are you an LPTV station? Are you a repeater or satellite station? And what that really means. So having somebody who's up to speed on that and understands those rules is going to be helpful.
All right, and there's a question that has come in. Do you know if every LPTV station that did not report received the letter?
I do not know if every LPTV station, I don't know what the threshold was. What I do know is, from my understanding, it's been licensees large and small, some with a lot of stations, some with a few stations, some that are predominantly full power licensees that have some LPTV stations, some that are primarily LPTV licensees. It's reached far and wide. So I don't know if there was a cutoff, if it was 3 stations, if it was 5 stations, if it was 10 stations that didn't report, or if it was just sent to everyone. But I do know that they sent a lot of these letters out.
Okay.
Leah, if I can jump in, you know,
Sure.
I think one thing that's we in the LP space have, it feels as though we've had a tendency to have an us-them mentality when it comes to the commission. And oftentimes what I hear kind of, you know, from different people is this, you know, vilifying the commission when they send something like these letters out. And I think it's important for us to keep the perspective and the frame of mind that, one, whoever you're dealing with or whoever sent you that letter is not likely the same person, group, division that you've been dealing with other issues. You know, it's a big organization that's working with us, but two, they're not out to get you. They're trying to make sure that we're serving the public, because ultimately that's what our license is for. It's a license to serve the public. And one of those things within that license to serve the public is to make sure that if there's an emergency that's out there, there's a method to be able to communicate to that public, hey, there's an emergency and you should be aware, go look for cover, or whatever the emergency might need. And so with the EAS test, this is simply a mechanism of making sure that the lines of communication are in place and that we're doing what we're supposed to be doing. And so when it comes to how we respond to these letters, we don't need to be reactionary. We don't need to think they're out to get us or think that it's an us them, or that they chose to just pick on us. It's really just they're trying to make sure that the lines of communication are properly in place. And if there's a legitimate reason why they didn't get a filing from us, we simply explain it in a method that is easily communicated, which is why we would engage someone like Ari and Wiley Ryan to help us explain the story on why we didn't, you know, file a form for this station or that station, and how that non-filing is in line with what our regulatory environment is calling for. So it's just, I think it's healthy for us to keep a good perspective on this isn't an attack. This is just trying to make sure that the lines of communication are in place.
Right.
And I think one other point, just to what Josh said on the out to get us, I mean, I think the initial reaction among some in the LPTV community was this is an attack on LPTV specifically. And some color for that is, I know, you know, number one, there are full power TV stations that were also targeted by these LOIs, and there were radio stations that were targeted as well. So this is not just an LPTV issue. I think it's going to hit LPTV harder or more widespread just because the response rate was lower among the LPTV community. So more LPTV licensees likely received these letters than maybe other broadcasters, but it was not targeted at LPTV. This is a broadcast-wide issue.
Right. And that's something we discussed earlier, back when we did the test, that the FCC was concerned about the response from LPTV and the LPTV industry. That's the reason we were so much on the, you know, please respond, fill out your forms, send it in, so the FCC knows you exist out there. And I think if we'd done all that, maybe there wouldn't have been a requirement for that. But I don't think it was something that because they did not participate in the test or send in that letter, is that what maybe keyed this back from the test?
Yeah, I mean, I think it certainly goes back to the test, and it was targeting folks who didn't respond to and didn't fill out one of those forms. If more, again, I think one of the things that the FCC is trying to find out is how much of this was broadcasters that were supposed to be filling out the forms and retransmitting the tests who just didn't do so, and how much of this was broadcasters who had a reason, had a specific reason, and maybe it was within the rules for them not to comply with those requirements, and the FCC was just undercounting. And unfortunately, as licensees, as FCC licensees, sometimes you have to go through processes like this, responding to an enforcement inquiry, just to provide the FCC with information, even if you didn't do anything wrong. And it's unfortunate sometimes that you have to go through that time and that expense. But I think part of this really is just a fact-finding mission on the part of the FCC.
All right, we've got a lot of check boxes to get through today, so we'll move on to that. And we did a recent filing, a reply comment in the ATSC 3.0. Tell us a little bit about the filing that the ATBA did.
Sure. So this proceeding relates to the ATSC 3 transition. And as many of you know, under the existing FCC rules, there's a process in place for stations, whether full power or low power, to enter into simulcast arrangements. So one station goes to ATSC 3, they host a bunch of other stations in the market in ATSC 3, and then they offload their ATSC 1 content to a different station in the market to host that content going forward. When the FCC adopted those rules, they didn't specifically address what happens to multicast streams. And this gets particularly complicated when you've got a station that's got, 3, 4, 5, sometimes more multicast streams, and there isn't enough ATSC 1 capacity on a single station to carry all of that content. So not only do you have to figure out what station's going to carry that content, but a lot of times you're going to have station A is going to have your .2, station B is going to have your .3, and station C is going to have a .4 and a .5. And the FCC just didn't account for that at all when they adopted the initial rules for the ATSC transition. So to date, the FCC has been dealing with it on a very ad hoc basis, and licensees have been coming in filing for special temporary authority to put their multicast stations elsewhere. And I guess taking a step back, what's the reason why you need authorization? I mean, one thought is just to enter into a programming agreement with other broadcasters the way you would if it was leased content, if somebody was leasing a subchannel. And that's certainly an option in some situations. But number one, in that situation, it's the broadcaster who's got the license who's responsible for any violations of that content, as opposed to the originating transmitter. Now, you can account for that contractually, but it certainly just complicates things. And do you want to have to go through, as we're talking about FCC investigations, do you want to have to go through an investigation process just to point the finger at somebody else? And then the other issue is for non-commercial stations is whether they can carry a multicast channel from a commercial station, which they wouldn't be able to do if it was under their license. They can only do it if it's under the originating station's license. So a bunch of broadcasters have gone back to the FCC and asked them to adopt rules that address what happens with multicast stations. And the FCC put out a notice of proposed rulemaking addressing the NAB petition and essentially saying that they would allow stations under most circumstances to license their multicast channels on different stations in the market. There's some open questions about how that will work, but that's the general concept. The real problem, not problem, but I think oversight in the notice was it dealt with the full power transition. And aside from a very brief rule change at the end. It didn't discuss at all what that means for low power stations. And while there's rules in place for simulcasts of low power stations, it left some ambiguity as to if they change the rules for full power stations, if a full power station is sharing with a low power station on a multicast, do those changes extend to the multicast stations? And do they address low power stations sharing with other low power stations? So we filed comments that number one said, above all else, whatever you do, make sure you specifically extend whatever rules you're adopting so there's no ambiguity that they apply to sharing involving low power stations. It's the same thing the FCC did in the first place, but make sure that you're doing the same thing here. And then we also said that there's some special circumstances for low power where low power can serve fill some voids in this transition that the FCC should account for. So for example, there's a default processing guideline that if your simulcast station reaches at least 95% of your population, the FCC will provide expedited processing. And in a lot of markets, there just aren't other stations that that serve 95% of one station's coverage, or it may be that there just aren't enough stations to cover everybody. And low power stations can serve and can really fill that void in a lot of markets. It's a potential opportunity for low power stations to step in and to serve as those gap fillers. So we said that the FCC should also specifically acknowledge that and address that role that low power stations can play and make sure to facilitate a role for that.
All right. And I just noticed I had not posted those to our website. So I'll do that after this webinar. I'll be sure and post those at broadcastingalliance.org for everyone to see. You can also look those up at the FCC, but I'll post them where they're nice and easy. All right, that's another checkbox. Foreign sponsorship. Now, I know you could spend another hour on this subject alone, and it's something we don't think about. We really don't. And just FYI, the questions out there, we will get to what the Senate did yesterday. We are going to get that's on our boxes. So just hang on. We'll discuss the Class A situation. So in regards to foreign sponsorship, a lot of people don't even think about that issue. I mean, the ATBA has a significant amount of foreign sponsorship, but you don't think about those things. And this is just a business example. You don't think of some of our gold and platinum sponsors being foreign organizations, but they are. So now the FCC, we've got to look at that. So tell us a little bit more as quick as you can, and we'll probably come back and do a full session on foreign sponsorship identification.
Yeah, sure. So, and this is another one where, if you've got legal counsel, talking to them about what to do, I think is going to be really important in figuring out how to navigate this, because this is not easy. This is really complicated stuff, and it's tied up in court right now. The NAB and some others are challenging these rules because they're so complicated and because they put such a burden on broadcasters for compliance, and that includes low power stations. So that's why we wanted to be sure to address that today. So last week, the FCC actually adopted these rules last April, but they've been on hold, a lot of the requirements, because they were subject to approval from the Office of Management and Budget, OMB. And just last week, they announced that the OMB approvals were complete. So those rules became effective last week as to any new agreements that stations enter into. They're effective in 6 months for any existing arrangements. And the real high level requirement is that broadcasters have to provide identification on the air, the same way that broadcasters have sponsorship ID for products and for placements and for political. They also have to identify content that's sponsored by a foreign government. So, you think Radio Sputnik being one of the examples, you think some of the foreign television, whether it's, Japanese-based television from NHK, whether it's, German, whether it's Korean, we see a lot of that on the air. And if it's foreign government sponsored, the requirement is that you identify and make very clear who's providing the programming and what country it's being provided on behalf of. And there's a burden on the broadcaster specifically to make sure, you can't just say, well, we didn't know, so we didn't disclose it. So you've got to ask the question when you sign your agreements. And you may think that your programmer's completely innocuous, right? They're doing religious programming, and you say, well, I don't think this is religious programming. It turns out it's religious programming sponsored by, the Communist Party in China, right? So you need to ask the question, and this puts the burden on the broadcaster at some level. When you sign an agreement, when you renew an agreement, to ask the question. You're supposed to be checking the Department of Justice lists and the FCC lists to see if the people you're acquiring content are registered as agents of a foreign government. And then ultimately it's advising your lessees, the people who are acquiring airtime from you, of their obligations, both to disclose if they are foreign government owned and to provide the proper sponsorship identification.
All right, so just something to be aware of, and we'll try to come back to that and break those details out even further. All right.
Can I add some of that real quick? Because I know that, initially when you hear that, it's just one more hoop you've got to jump through. As an LP, as a broadcaster in general, it's like, I don't want to have to add more work to my process. But there's some valid reasoning behind it. A lot of the state-sponsored media, it's a soft war approach where other governments and America participates in this just the same. If you can influence the people of the other country by going through their pop culture and their media to get them to think a certain way, then you have an indirect approach to influence the government from a bottom up. And so it's not just an empty requirement of why they would want it to happen. Other governments will buy ads in our newspapers and have those ads be designed to look like actual news from the US, only so that they can impact the US reader, thinking that this is viable news that is characterizing the things they want, the way they want to characterize. So it's a valid regulation with good reason.
Right, and I know, as also an owner of a public relations agency, we have bought ads here in the United States on behalf of other governments. We've done that, and the client and the stations probably had no idea that it was from another government. Now, obviously, we were doing good stuff, but those stations had no idea that it was a state-sponsored ad. So it is a very good rule, but it does give us a lot of headache to consider, and it's for protection of our country, and I understand that. So we'll dig into that a little deeper, unless you guys have anything else you want to do on that subject. All right. The question that came out yesterday is the Low Power Protection Act that was in Senate committee yesterday. And there were some other things in the media that were not very nice to these senators. And anyway, but let's go ahead and give us some background, Ari.
Sure. So this act has been in the works for a while, and I think, since I've started practicing law, there's been, is there ever going to be another Class A window, right? How do we protect LPTV going forward? It certainly came to the limelight during the incentive auction, in terms of protection during the repack, in terms of eligibility to participate in the auction. But I think there's even beyond that a general concern among the LPTV community that, we're investing resources, we're investing time in trying to build out stations that are serving the public. And at some point, we should get some protection for that. We shouldn't always be at the mercy of what happens outside of our control that could push us off the air. So certainly a valid concern among the industry. I think there's some pushback against that, on the other side, to the extent that that limits flexibility of full power stations, to the extent that that limits flexibility of other services to use broadcast spectrum. So the concept of this act was to provide a new Class A window. and at its core, that's really what this proposal does. It creates a new Class A window that models the window from back in 1999, with one important caveat, which is you have to do all of the things that stations were required to do back in 99. So you have to do your locally originated programming. You have to meet your minimum operating requirements. In addition to that, the statute, as the bill is originally proposed, drew a line and said it's only the only stations that are in DMAs that serve 95,000 households or fewer are eligible to participate in the new window. And obviously you go through and you do the math and you look at what markets that covers, and it's not a heck of a lot. Right? That 95,000 threshold falls pretty low down in the Nielsen rankings. So it provides, and if you want to be a skeptic, you say this provides protections to stations in the areas that need it the least, because they're the least likely to be displaced in those markets. So certainly there's some good that comes out of this bill, in that 23 years later there's finally some talk about how do we protect low power going forward. And I think that's overall a good thing for the industry, that Congress and that the FCC are thinking about how to protect low power. With that said, I think the bill falls short maybe of what some people within the community were hoping for. And I think that's where some of the negative reaction came out. So the bill was introduced. Yesterday, it went through committee markup in the Senate Commerce Committee. It was adopted with a very minor clarification that basically said this doesn't affect anything relating to the incentive auction, whether it's reimbursements, eligibility, anything related to that. But essentially, it's the same cutoff of 95,000 households, and it's the same bill that cleared committee. Where it goes from here, hard to say.
Right.
As with anything in Congress, the mood changes, Congress's priorities change. Does this get thrown into some larger bill, and does it get passed? Does Congress lose interest, particularly if there's criticism on some sides of this bill? Maybe they decide it's just not worth going forward. I don't know. NAB has been very supportive of this bill. We as an organization have come out and said it's a good thing. It may not be everything we wanted, but it's a good first step. So hard to say where it goes, but it made it one step further. Now it's got to get through, through the Senate. It's got to get through the House. There's a long way to making this a law, but it's one step further after yesterday.
Right, and true, us as an organization, as the ATBA, we basically applauded what they've done at this point in time, because it's a start. In other words, it's someplace to start, versus then it just getting thrown out and not going anywhere. Now there are some of us, and obviously every day we're going to push for permanence whenever we can, because that's what we are looking for in the LPTV industry. But there are steps that we have to go through, with the FCC, with the Senate, with legislation to get there. We just can't jump there. We've got to be sure that, NAB, full power broadcasters, all of the others are on board what we do. In other words, for that to be pushed through and to make it. But there's a new change here. The ATS, as you said, this comes back from 1999 when Class A originated, the same rules. And the broadcast industry is changing. And now we, as LPTV, have ATSC 3.0. The whole operations of any TV station, whether it's full power or low power today, are nothing like 1999. So do you see any potential to maybe update these rules, or to maybe think about, okay, if you build ATSC 3.0 as a station, would that qualify for some permanence or Class A? What are your thoughts on that?
Yeah, I think, the regulatory world tends to change slowly. So I think you'll see the industry move first and then the regulations catch up in a way. But I think down the road, that's certainly a possibility. I mean, right now, and part of it's getting a push from Congress too, potentially. I mean, I think the FCC's view on ATSC 3.0 is we're going to tolerate it. We're going to, facilitate it where we can, but we're not, the FCC hasn't fully embraced it. The FCC's has never come out aside, some of the stuff maybe out of Commissioner Carr's office has been a little bit more optimistic on, ATSC3 and broadcast internet, but as a whole, the commission has not come out and said, we see this as being a great public interest. But I think that's going to change. And as we see the rollout continue, and as we see broadcasters start to show this isn't just a theoretical concept of what we can do with the spectrum. Here's some real world examples of what we're doing with the spectrum. Here's how it's being used to provide, whether it's distance education, whether it's filling in, helping provide just better reach for broadband services, whether it's providing other services that we haven't even thought of yet. I think as that message starts to come out and as broadcasters start to tell that story about what it is, I think you're going to see the FCC start to embrace it more. And maybe more important than that, you're going to see the policymakers in Congress start to embrace it more. And as we saw with Class A back in '99, it wasn't that the FCC was so excited about low power television that they said, let's open up this window. It was Congress that said to the FCC, you're going to open this window, and here's what the window is going to do. And I think that this is the first step in that process. And I think the more that the industry is out there educating Congress about why it's important to provide protection, that's probably where change is going to come from, is going to be through legislation, not through the FCC doing something on its own.
Exactly. And ATSC 3.0 is a different changeover than when we switched to digital. That was government mandated. This is consumer mandated. So or consumer driven, a much different changeover. But
I think that's a big reason why we should be on the LP space, why we should be more bullish on 3.0, because the whole argument on we deserve permanence because we're providing a service to the public, right? That's the argument. We've invested, we're providing a service, lock in that service and give us permanence. And what they're saying is, if you're giving a service, but a full power is going to give a much bigger service of the same type of service if it's linear, right? And so they're saying nothing's changed to make them all of a sudden give a permanence, right? But to Ari's point, if we're bringing new services to market and we're providing a new service to the public that they're not getting elsewhere, then it's a lot harder for them to allow us to go away. We're too important at that point because we're doing things nobody else is doing. And so
right.
the best way to accomplish our permanence is to prove our value. And the best way to prove our value is to build out and serve the public in the most efficient, effective ways that we can, which in my opinion is 3.0 and all of the different verticals that we're working towards in 3.0.
Well, and somebody has posed the question that you could probably see there, and I won't read the entire question, but basically saying that the FCC is giving preference over LPTVs that are on deadline, that are building out ATSC 3.0, giving special exemptions not afforded to those that want ATSC 1. I don't think I've seen that out there. Is that something you guys are seeing out there, a special preference to LPTV stations that have CPs that say, hey, I'm going to build ATSC 3.0, so give me a special exemption? Or
Ari's cautiously, he's like, I don't know if I want to answer that. No,
I haven't seen it.
I can tell you, no, we don't feel any special preference, and we're obviously.
I was going to say yes, Josh. You're building ATSC 3.0.
We are building ATSC 3.0, but no, I haven't felt any special preference. We're having to make our case just like everybody else, and in fact, ARC with what we're building out, historically, we've handled our own filings, and the commission was pretty straightforward with us. Look, you're not really giving us a strong enough argument you're going to have to do a better job of explaining why things were outside of your control, because, you know, you're not clarifying it enough. And so we engaged the services of Wiley Ryan to help us with exactly that.
Oh, so you guys use, all right, well.
So we use Wiley Ryan for that reason. And, you know, we're still in the middle of that process, but like we did have things arguable, it's not just a story, things are outside of our control. And so when we can demonstrate that we did everything in our power to accomplish those deadlines, and things that just were simply outside of our control, we're not talking business decisions, we're not talking finance decisions, we're talking things that are outside of our control that are acceptable in the ruling of a tolling request and the warrant of a tolling request. We have to make that argument. And if we can't make that argument, then we get the same thing as everybody else. It doesn't matter with 1.0 or 3.0. In fact, the commission, from that standpoint, they don't care whether you're 1.0 or 3.0. You're either a license serving the public or you're not.
All right. Well, I don't know, Josh, if you can see the question that has popped up, or maybe more clarification of the question. Is that something you want to address?
Edge spectrum file for the extension because of ATSC 3 and is attached to the request for extension. No, we didn't. We're not making.
Well, come to say, you are Edge Spectrum as well.
Correct. Yeah, the Edge Spectrum assets are, that's within our portfolio.
Okay,
and,
so you can personally speak to this.
And in our discussion with the commission and our filings, we're not. I mean, we're clear to tell them we're going towards 3.0, but that's never our excuse.
Okay. All right, gentlemen. Now I think have we checked all the boxes that we wanted to get to today?
I think we've covered quite a bit of ground.
All right. Well, let's get to Josh and put him more on the spot at this point. For the last 2 weeks, we've discussed what ARC is doing out there in regards to ATSC 3.0 and how you are monetizing that. And I just wanted to bring you back today because some folks had some questions that they wanted to put to you, some more specific questions. And folks, this is your opportunity. If you watched last week's presentation and maybe caught a little bit of the full presentation, maybe live at NRB, and wanted to ask questions of Josh, this is that opportunity at this point in time. Just put that question in the question box there, and do something that'll stump him here. Don't give him a softball. Nobody's wanting to put you on the spot yet, I see, but I will say that we will have, we're going to edit the 1.5 hour presentation down to something that's a little bit more manageable for people to watch. I'm sorry we don't have that ready today. We've just been extremely busy, and I have to lean on the volunteer services of our in-house media agency here to take care of things like that. So, but we'll have that up hopefully here in the next week. Okay, my symbols turn red here. All right.
So it's a long one.
They've written a book here, and they're anonymous. They don't want to tell us who they are. And it keeps getting longer.
So this seems more like statements. What would be the question here?
Yeah, I'm not sure. I don't see a question. And maybe if our anonymous person has a specific question they can present to us.
So this seems, again, there's no question here. It really seems more like a grandstand without a name behind it. So I don't, like, I can't answer a question. I can't statement. So if there's a question, I'm happy to answer a question. Yeah. So as far as will ARC partner with LPTV stations in various parts of the country? Yeah. You know, the way we have viewed 3.0 in general is that we're going to have the best opportunity to serve the public by having ubiquity. And ubiquity doesn't mean one person owning everything. It means just like interoperable roaming in the early cellular days, being able to go from one station to another, one frequency to another. And it doesn't have to be one owner to the same owner. It can be anybody in the market, right? And so ultimately, the way we see success as the 3.0 world matures, it's going to be the opportunities for the Amazons, the Netflixes, the various enterprise type customers trying to get data from one to many, them being able to go across one interoperable network. And so for that to work, yeah, partnering with other broadcasters, and it doesn't just have to be LP. It can also be, LP to full power to LP, LP to LP. There's a lot of different ways. Obviously, there's some maturity that still needs to happen there, but that's definitely an intent, of course.
Right. And if you're watching some of the news at the broadcastingalliance.org website this week, there was an ATSC 3-point handoff testing demonstration.
Yeah,
between WMYD in Detroit and WKAR in Lansing, where they actually did this ATSC 3 handoff.
Which is a big success point that, a car has to be able to, just like with your cellular, you jump from tower to tower, being able to jump from frequency to frequency, station to station, market to market. That's a big thing. So it's a success, and I really commend them for a job well done there. As far as the turnkey solution, we deal with the standard for a reason. The standard should be able to work no matter what. And that's why, it doesn't matter who your vendor is that's providing your 3.0 stack. It should be standards based. Where we're still in the midst of development with regards to the standard is on the ATSC 3 core side of things. So from an orchestration layer, you've got to be able to orchestrate that content where a customer, let's say Netflix wants to send a file or Ford wants to send a file that's going to go across the entire network nationwide. There's got to be some level of consistency in a national network operations center being able to go to other broadcast stations and making sure that's going to work within your architecture. And so that's that from a turnkey standpoint. The turnkey within the ARC side is, this is our orchestrator. This is what our build looks like. We're not there yet to be able to start providing that for everybody to build out that way. But in theory, that would be the way to go.
All right. What's a ballpark building out of 3.0 compared to 1.0?
So a lot of that's going to come down to some of the business decisions you choose to make.
I guess talk about, some of the same pieces of the puzzle in 3.0 and 1.0.
There is, you've got the same encoder side of things. So it's going to be a matter of how many linear channels do you want to have a license for, HD, SD, as they grow from there, you can imagine. So there's costs there. But other business decisions, of course, there's the stack, your scheduler, your packager, your gateway. But beyond that, do you want redundancy or not? Do you want to make it to where if something breaks, it automatically kicks over to a second stack or a second set of hardware to make sure that you stay consistently going without any kind of break or hiccup in your data casting? Then there's also the component of the orchestration side of things. Do you want redundancy there? So in the end, you can have a build that's a pretty big range, because your amount of servers and the hardware that's there and the software that's there immediately can be doubled based on what you're doing. So from ARC's standpoint, we've got in not including our Exciter, not including the EAS, just in the actual orchestration, the stack, and the encoding side, we've got 7 servers, which is all put into 2 Edgeline EL8000 servers that are the HPE EL8000s. Those 7 servers in 2 5RU chassis is what it's taking for us. And so then you're going to talk about the cost based on what level of storage you want in there, and some of the other things that you can obviously add to add more power to your deployment. So it's not as simple as what's the cost of one versus the other, because you have to identify what it is that you're deploying, right? And I don't think it's any secret we're deploying a Hewlett Packard enterprise on the HPE on the orchestration, and we're choosing the HPE servers at the moment. We're using at the moment Aruba switches, which is also under the HPE umbrella. And we've been very happy with our solutions currently. At the moment, we're deploying a TEM encoder, and very happy with the TEM and their participation. We in our current 10 stations, we've got Treveni solutions for the 3.0 stack, and for an RF, their stream scope for RF monitoring. And we're deploying at the moment the DAS deck for the emergency alert. And, we're very pleased with where we're at and always exploring more things, but the costs definitely there's a lot of variables to look at.
Yeah. How about transmission and antennas?
So transmission, we've been very committed with Comarch. They've been a great partner of ARC, as well as Comarch Digital Services. Tim Hosmer has been a great partner on the 3.0 implementation and the design side of things. We've worked with both Katrine and with Dielectric on the antennas for what the deployments are currently, and they've been great partners, both of them. And ultimately, I think the industry succeeds when there's multiple vendors and multiple vendor options. It provides a good accountability to one another. It provides there's benefit in competition, of course, but there's also more innovation that takes place when people are working to improve their product, with the others that are out there in the market. So we're always looking at alternatives and staying very committed to those that we're working with, but looking for ways to continually improve too.
All right. It looks like our questions have ceased, and we have run out our 30 minutes and running out of the hour, but I guess with 2 guests, we can get away with that. So I'm going to put back up our sponsorship screen and show some of our sponsors, and these are our gold and platinum sponsors that you'll see on the screen. Also, I just noticed this screen says October 11th on it, but it's April 25th. And here are some of our sponsors. Some of the companies that Josh named are there, plus many others that are participating in the ATSC 3.0 world as well. Our event at the Embassy Suites Convention Center is coming together quite nicely. I met with them on Monday, and to make sure that facilities and food and drink were in order for our event. Also, the NAB has relaxed their health and safety rules. Before, you had to have a COVID vaccination just to get in. Now you can have a test, and I believe my understanding is they're going to provide some testing right there on site to get your "I've been tested" card. So you can have a test or your vaccination card and be able to attend the NAB. Ours is not going to require an NAB pass to get into our event. Business card is all that's required to get into our event at the Embassy Suites. Our main event starts at 6 p.m. for members and 6:30 p.m. for all of everybody else for the reception that evening on the first floor of the Embassy Suites. And we have events starting at 9 a.m. on that Monday, April the 25th. And we will have events running up till 4 o'clock that day, roundtables, talking about all sorts of various issues from news, ATSC 3.0, EAS, PSIP, all of those things that you would expect us to, the nuts and bolts of the LPTV world. And matter of fact, I've got 2 slots open. If you have a subject matter that you'd like to cover, I would love to put that in the slot. I'm making this schedule hopefully final by next Wednesday. And so we'll be back with one more session of the Wednesday webinar this coming Wednesday before we get into NAB season, April 25th. Be sure to mark that on your schedule. And I appreciate the excellent presentation all around from the gallery out there, Josh and Ari. I appreciate you guys so much for being with us today, and keep us informed out there. And so if somebody, go ahead and give us your email addresses real quick, just in case somebody wants to direct message you.
I'll let Ari go first.
Sure. I'm AMELTZER@wiley.law.
And
All right.
I'm Jay Weiss, WEISS, Jay Weiss at arkmulticasting.com. And Lee, just so you know, we did do the drawing for the
Oh, that's
free
right.
Sony
Who won the TV? Okay.
television. Matt Cook from Aberdeen. Matt Cook from Aberdeen. And so
Let's get a little
reaching out to Matt.
captioning going here.
yeah. So excited about getting him that TV.
All right. Appreciate everybody that registered for that during the presentations in the last 2 weeks. And that was a 65-inch TV given by TVN, Sony, Next Gen Ready TV. And maybe we'll have some other prizes coming up on the LPTV Wednesday webinar and at our reception on April the 25th at NAB in Las Vegas. So that is a wrap. And good night, everybody, and God bless. We'll see you guys next time.
Thanks, everyone. Thanks, Lee.
Thank you. Take care.